Yeah, well, again, we welcome questions from other members of the committee, but with respect to this, Dr. Amy, who's one of the crafters of the Oregon laws here, I'd ask him to come up and maybe respond specifically to the question. In terms of remedies for alleged coercion, a family member, a patient, a doctor can all report to adult services, to the district attorney's office, to the police agency. There's nothing in our bill that prevents bringing in law enforcement and existing elder abuse authorities to investigate an allegation. It can be made by the patient, it could be made by a family member, it could be made by a doctor who suspects coercion. There's nothing in our bill that creates insulation against an investigation. If we could introduce Mr. Amy, who is one of the crafters of the Oregon law and has followed its implementation, could, through the chair, ask if he could just respond to those concerns about Oregon's apparently weak protections against coercion.
I would appreciate that, and then Senator Hertzberg. Thank you, sir.
My name's George Amy. I was Oregon legislator when this bill was first introduced and passed in '94 and '97. I then became the executive director of the organization that was founded to implement and facilitate people going through the law. I'm now on the National Board of Death with Dignity National Center. And as to the specifics that Marilyn has brought up, the mechanisms that we have, first of all, the procedures. You cannot emphasize them enough. Number one, it has to be the request of the individual, not anyone else. No one else is going to be a surrogate and step in and say, I want to do this. The individual has to do it. Now, then they have to wait the 15 days before for the first and second request. Then they have to sign a written request, witnessed by two people, one of whom cannot be a relative and another one who cannot be part of the medical providers. And then 93% of those individuals who take the medicine are enrolled in hospice. To enroll in hospice, you have to have a 6-month prognosis, a terminal diagnosis and a 6-month prognosis, and acknowledge that you no longer wish to have curative care. You can have comfort care, but not curative care. Before you get enrolled in hospice, you have to be examined by a physician, and you have to go through a mental evaluation that this is your decision, voluntarily doing so. Then you have to go through the process again. As I've often said, going through that process is a rigorous process. The average length of time is not 15 days, it's 45 days. People who start from that first request to finally getting the medication. And it's because they have to make appointments with the doctors, they have to be interviewed by the first attending physician, then a consulting physician, and if either one of them believe that this person is severely depressed, they have to go through a psychological evaluation. All of these protections are there so that the individual is not in any way coerced, unduly influenced. Then comes the most difficult time of all, which I have observed in my 12 years handling over 1,600 people who died, over 450 of whom actually took the medicine to end their suffering. It is, when do I take the medicine? We all want to live, and these people want to live as long as possible. Suffice to say, the arguments that are used that they extend it for 2 years, sometimes it misdiagnosed. Well, they want to live. They don't rush to take this medicine. The number one question I had all those years was, when do I take it? And I would always respond, I cannot answer that question for you. Only you can answer that question. And it's a struggle. If you've ever seen the documentary How to Die in Oregon, it is a award-winning documentary, and it shows the struggle of the primary person in that film, of the decision that it took her to finally get there. So now, you have the medicine and you decide to take it. What are the oversights? Well, 98% of the individuals who take the medicine have someone there. Physician, hospices, family members, friends, and volunteers from an organization that helps facilitate people through the process. I have been present at more than 4 dozen individuals who chose to do so, and I can tell you that I've been there when only maybe 1 family member was present, and I've been present when over 150 people were present. A famous radio announcer took it, and he lived in a yurt, and 150 people went through that yurt to say goodbye to him. Well, the questions that are asked, and every single case I was ever involved in, number 1, do you wish to do this? Number 2, do you know if you take this medicine, you will die? Is this your decision and no one else's decision? Number 4, do you know that you can change your mind at any nanosecond up to taking that medicine? Do you still wish to proceed? And in all cases except 1, the answers were yes to all of them. 1 individual told me that he changed his mind and waited until the next week to take the medicine. I ask the questions to those who oppose on a regular basis. What would you do? Who would you have present to assure you that this is not going to be coerced? Who would you have in the room? They would have priests, they would have pastors, they would have police, they would have legislators. And I said, well, I've been there, so, but none of those individuals come forward. This is a very private, personal matter that they want to surround themselves with their loved ones when they say goodbye. And another safeguard, the study done by Dr. Linda Ganzini, Oregon Health Sciences University, studied a group of individuals, surviving family members whose loved ones did not take the medicine and did not go through the procedure, and a group of family members whose loved one did take the medicine. And the comparison was stark. Those whose loved ones took the medicine, each and every family member said, the dying process was the most beautiful I've ever seen, and their grieving period was shorter than the other group because their memory of the loved one dying peacefully.
Okay, thank you. Let's go to Senator Hertzberg, and then are there any other members who have questions? Okay, Senator Hertzberg, and then Senator Leno.
This matter has been before this legislative body for 20 years. I grappled with this 16 years ago when then Dion Ariner brought this measure before the other house. I parked that measure in appropriations and did not move it out. At the time, I thought that there weren't sufficient evidence, big issues, 16 years ago. And despite the extraordinary skill sets of both senators who are co-sponsoring this measure today, I held up making a decision. I did it for a number of reasons because I wanted to be thoughtful and give all sides a hearing in terms of what to do in this measure. And let me tell you, I've been around a long time and you guys are smoking it. You guys have done a brilliant job in terms of really elegantly doing the homework, building the coalitions, thinking through the details on probably one of the toughest issues there is. Because this, quite frankly, when you listen to the testimony, for those who don't want to move this forward, outside of the point that the chair makes, which is the larger ethical issues for doctors, ethical issues for religious groups, training issues where the palliative care folks say that really what's going on here is people really don't have choices, the arguments that I heard, because they're in such pain, they're not really making choices, and had they had the right care and the right hospice, they wouldn't be making these choices. They're just making it because of their circumstances. But in analyzing this, you know, I do think that this notion that the chair mentioned about oversight would be interesting to at least maybe include something about some process over time to make sure that this really is going the way it is. Certainly have a long record with respect to Oregon and the other states that have imposed this. I think that's an important observation. And secondly, I think that often that happens, these kinds of measures, in my experience, that people always raise technical issues to try to discredit your underlying effort. And some of those things might be important, the issues of who the witnesses might be. There's some minor issues in that regard, but at the end of the day, to me, you know, it's the status quo is not good for either side. What we've heard here is that there's mistakes on both sides. The question is, what's the role of government? The gentleman who made the point about God, what's the role of government? What is our job? And where do we default in terms of the rights of folks to engage in making decisions? And it seems to me, and really being deliberative and listening to everything and reading every piece of paper that anybody sent to me, that at the end of the day, that really it is the freedom of someone to make a choice. Is it free will? Because at the end of the day, what the arguments that I hear are free will, and that people don't really have free will, well, what does that really mean at the end of the day? And then as a government, what's the role of government in this? People have their own personal faiths, they have their own personal choices. I was talking to the chair about this issue in terms of the issue of choice and what the Constitution means. And our job is to create a government that gives people choices and make sure there's certain levels of protections. And I think after 20 years, it's time to make the decision and move this measure forward. I think you're going to fundamentally change the law in California. I think that you have thought this stuff through pretty elegantly with 1,327 cases, no litigation, compelling statement, right? Whether there might be more litigation in California, yes. So there are arguments about different kinds of the nature of healthcare today, sure. So maybe that would include some oversight in dealing with some of the technical issues. But I got to tell you, I think you've done a magnificent job. It makes me proud as a legislator, an institution that I love, to do this. And I think you've really developed a great case. And you know, I think there's certainly compelling moral issues on the other side, but I don't think that's for government to make that decision. So I just wanted to basically, A, talk to you about making sure the oversight's there, B, listen to some of the opposition. I think the arguments you made were pretty elegant, and there's some points there that need to be included. I leave to you on doctor shopping and the issue of distorted choice, but I think that a lot of that stuff's been dealt with. Maybe as you fine-tune this measure, which you've been doing all along, you'll deal with those issues which are important. But, you know, I'm voting for this, and I think you did a hell of a job.
And is that a motion?
I so move.
Okay. Senator Leno, motion has been made.
Thank you, Madam Chair. And I know I speak for all of my colleagues, for everyone who's come today to express your opinion, and it is your God-given right to have that opinion. And I don't know that we're here so much today to debate and to try to change those opinions as we are just to get some greater clarity, because this bill attracts the attention that it does because none of us are exempt from the issue we're talking about. It is the most basic part of our existence and our coming future. So clearly, it's going to be a very challenging issue for us, and you've been very bold and brave in moving forward. And for purposes of full disclosure, if you look at the front of the bill, I, along with Senator Jackson, am a principal co-author of the bill, and I'll get to my reasonings for that in a minute. From some of the presentations, I did have a few thoughts with regard to concerns for oncologists or any other physician, that this is permissive. No one is going to be forced to do anything. So that didn't stick with me too well, but I did want to ask the authors if you could respond to the same presenter's question with regard to, and it was mentioned by someone in public comment as well, that physicians will have to lie when they sign the death certificate. Is there anything we can do about that, or is that not really a concern, or why? What is the need for that provision in the bill?
The genesis of that being in Oregon and other states and included in ours, it's more of a legal reason than in terms of some life insurance policies are made they're made null and void if the end of life is because of suicide. By having the underlying terminal illness that is the primary motivator of somebody exercising this option, they're working within a death sentence, and within that, they're seeking, if they choose, to access the prescription and to choose the time of death that is certain, and they are exercising the autonomy to determine within that certain death, because of terminal illness, at what point they'll transition. So the legal basis, so some physicians will say, well, if I put the cause of death as the underlying terminal illness, I'm lying. They're looking at it through the lens of a practicing physician who would conclude that the immediate cause was the ingestion of the lethal prescription, but for purposes of a law that seeks to build in the safeguards that we've discussed and the protections against a family losing the benefits of a life insurance policy or being coerced by the terms and conditions of a medical insurance policy, this is what has worked in Oregon, and we believe it's well designed to work in California.
It's a fair explanation. I also would imagine that a physician who's going down this path and writing the prescription knows the end game, and if he or she were not comfortable with what will be asked of him or her at some point, probably would not write the prescription. Yeah. Okay. I do want to say to Ms. Golden directly, you are articulate, you are compelling, you were among the most powerful presenters today, and you do your job representing a very important and vulnerable community and constituency of all of ours. And I'm sorry we disagree on this today. I thought some of the responses to some of the issues you brought up were satisfying, but your voice is needed, and we're just going to disagree today, but I have such respect for the way you do your work, so I wanted to thank you for that. So how I got here, as I was about 10 years ago when Assemblywoman Berg authored her bill, and I was a co-author of that, has much to do with a family member or two, but also having experienced the worst of the HIV/AIDS epidemic 30 years ago now, and being as present as I was for my own partner's death and passing. And in the early days of the epidemic, long before antiviral medications and cocktails and all that is sustaining life today, it was a death sentence. And one of the causes of death for someone in that position because of the virus was something called wasting syndrome. The internal organs couldn't digest food anymore, and it was long, and it was slow, and it was irreversible, and it was torturous. And I lost count of how many friends I had who went through that process. And because of the situation and the way the virus worked, it was by definition a human immunodeficient virus, that there's no defense mechanisms anymore. So at the same time, people were wasting away, literally by the day, over the weeks and months. They were open to every possible next infection that could cause them only more torture. And that's an experience that doesn't leave you. And getting back to some of the comments Senator Hertzberg made, it's hard to make an argument that adult human beings cannot have a say in how this transpires. And there are no fine set lines here. You say, well, well, then what about suicide itself? Why should the government interfere with anyone? But we have to act as a community of people, and we have to protect. We have to protect ourselves from our own worst actions at times and those of others as well. And so we do draw lines. But in this situation, what we're talking about here, end of life decisions and choices and options, I feel very comfortable, I feel very compelled to offer my voice in support of the bill. And I've forgotten the name of the young woman. She may not think she was so young, she was younger than I am, who was at the press conference, who has, I think, lung cancer.
Jennifer Glass.
Jennifer Glass. She said something that will stay with me a long time. She said, I'm doing everything I can to prolong my life.
Yep.
No one should have the right to prolong my death. And I thought that said it all. So again, with full respect for everyone here who has a difference of opinion of my own, I'm strongly in support of the bill.
Thank you, Senator Leno. Any other comments? I would like to just, there was one issue that I did not address with Mr. Ford, the concern about physicians determining coercion. And I would like to ask whether, and then ask for the authors to respond, but since you're here representing the oncologists, you know, these are people who deal with death and dying on a daily basis. I mean, the goal is, of course, to put someone in remission or to see the disease gone for as long as it can be gone. But people who have cancer tend to, you know, there's a great percentage who die from the disease. Are you suggesting that physicians are not capable of determining coercion? And if that's the case, would better education, we've done more with palliative care, recognizing the dying process really has not been addressed in medical schools and with the priority that it should, regardless of how someone decides to pass away, to end their lives. I mean, palliative care is very important under any circumstances. Or what exactly is your concern about the your characterization that physicians should not, that it's a legal question, not a medical question? How can we address that?
And I think it's a good question. That does go back to my point. I think even if we educated physicians more about palliative care, hospice care, you're asking physicians to make a determination with information that in fact may not be in front of them. When you're determining coercion, whether it's financial coercion, whether it's family pressures, any of those things, a treating physician very likely does not have that information in front of them to make that determination. There are huge court cases about coercion and determining coercion. It's usually, as I say, it's a legal matter. In my mind, and I think the mind of my client, not a medical issue and not something physicians should be involved in. Their training is in treating the disease.
Well, I understand that, but is there any indication that in Oregon the doctors didn't understand that concept, felt that they weren't in a position to make that determination? Is there anything in your experience, doctor, here or in your experience observing the process where doctors were not adequate in identifying coercion from a medical perspective? I mean, there is legal coercion, certainly, but again, we've defined a very tight period of time, a diagnosis of a terminal disease. Has there been a problem under existing law? And if there is something, do you have any suggestions on how we could address that? Because again, we want to...
Dr. Rich, I believe.
Dr. Rich?
Madam Chairman, I work closely with physicians. I have for over 30 years. It's always present in their minds when they're engaging with patients and families, whether or not decisions that are being made, which may not be consistent with their view of how the case would best be handled, are inconsistent. To me, their antennae are out all the time for that. They become quite intuitive about this. But the bottom line, I mean, I've been lecturing students about informed consent for most of my 2 professional lives. And I tell them that a consent that is not fully informed, that is at all manipulated or coerced, is no consent at all. So whatever the intervention is, if you don't ferret that out, you're proceeding without informed consent, and that is a violation of medical ethics and medical jurisprudence.
I would just also add on that point, in our bill, we build in for the 2 physician consultations that are required. If there's any doubt about decision-making capacity, our bill provides for the referral to a psychiatrist or psychologist who can assist in that evaluation of the decision-making capacity.
And just one other thing, we are explicit in the law about the fact that no power of attorney may be used. This cannot be used by a conservator. It is truly the individual that has to make that determination with the physician.
And is it your position, Mr. Ford, that a doctor can't do that?
It's not my position, of course, that my clients are not capable of understanding coercion, but it is the position of my client in the case Ms. Golden cited. How would any physician have known that the caretaker in that case stood to inherit the patient's house?
Okay. Okay. Did you want to respond?
Just a footnote to this. In the 17 years since the enactment of the law and the implementation of the law in Oregon, the relationship between the physician and patient in Oregon has improved. Dr. Linda Ganzini did another study with physicians and found that they now have longer consultation periods, that they're more confident in their relationship when the patient brings this issue up, and they are more open and honest with their discussions. So that's another benefit that the law has provided that we did not anticipate. So it's.
Thank you. All right. Seeing no other questions, I just, to basically sort of carve this or parse this down, I look at this as a question of giving people choice with protections. And should this measure pass, I would urge the opponents, and Ms. Golden, very clearly thoughtful, articulate representative of the disability community, I would invite you to all participate in trying to discuss this so that we do have all the protections that are reasonable. From hearing about what's going on in Oregon, it sounds like those protections are in place, that we're seeing this as a very positive step, both for patients and for the doctor-patient relationship. I think that's critically important and would urge you going forward with this bill, should it pass, to make sure that all the protections are in place while we give people that choice to participate in the decisions about when they do die as a result of a terminal illness.
Thank you, Madam Chair.
So if you'd like to close.
We'll give a brief close. You've been very generous in structuring this hearing and affording everybody full opportunity. We appreciate that. I also just want to offer my thanks for the engagement of our opponents, the very principled nature of that, the very real concerns that are shared. I will say that within the communities of opposition, none are monolithic. Among physicians, there are supporters and opponents. Within the disabled community, there are supporters and opponents. Within the religious community, there are supporters and opponents. The reminder is this is 100% voluntary. So nobody gets mandated. A patient doesn't get mandated. A physician doesn't get mandated. A medical community doesn't get mandated. A religious community does not get mandated. And just a reminder, the status quo in California, we have already established a right that is practiced in hospice care, palliative care, end-of-life care, that it is the law of the state of California that a patient using an advance directive can direct a physician to hasten death by not extending life. So California has already established that as a legal principle. Under the status quo, however, without the established right for somebody with a terminal disease having the ability to exercise an option as exists in Oregon, in which we seek to establish, we see horrific end-of-life scenarios, including people ending a terminal illness with a gun and traumatizing family members with that as the final memory of the loved one who was declining because of a terminal disease. So the status quo is susceptible to abuses. prolonged sedation, et cetera. What we believe that by establishing this as a right in California, we will also expand and enhance family discussions, use of hospice care, use of palliative care, use of comfort and pain management, and advance a conversation that is in many ways ahead of the legislature right now in the state of California and other states. So we respectfully close. My colleague will have her final words, but again, with our appreciation for all stakeholders in this and for the compassionate means by which you've conducted the hearing today, and respectfully ask for your aye vote. Thank you.
Thank you very much, Senator Walk.
Thank you, Madam Chair, and members. We both appreciate the nature of this hearing. This is the second we've had before the Health Committee and then before your committee, and both have been characterized by civil discourse and a real effort to really look at the nature of this bill and to its underpinnings. I wanted to say that both my colleague and I, we believe that this is a fundamental right. One has a fundamental right to a peaceful death, and it's really time to give Californians that basic right. So on behalf of both of us, I ask for your aye vote.
Thank you very much. And I want to thank all the witnesses on both sides and all the people who've come to just identify themselves in their position. This has been, I think, a very, very meaningful discussion, a very important one. You know, I used to say that life doesn't end well, but perhaps under the circumstances, maybe we can make life end as well as possible. So with that, Madam Secretary, there is a motion.
All right, the motion is due pass as amended to Senate Appropriations Committee. Jackson?
Aye.
Jackson, aye. Vidak? No. Vidak, no. Anderson? No. Anderson, no. Hertzberg? Yes. Hertzberg, aye. Leno? Leno, aye. Monning? Aye. Monning, aye. Wachowski?
All right. We do have, there are sufficient votes, but we will leave the matter on call for the absent members. Thank you for the opportunity to have this hearing. Thank you all for your testimony. And if we could have people leave quietly so we actually still have a whole day's worth of activity. But thank you all very much for being here.